Welcome to the second part of our September 15th training program for local officials provided by University of Illinois Extension's Local Government Information and Education Network. I'm Rick Atterbury, Media Communication Specialist in Information Technology and Communication Services at the University of Illinois. Today's session on the Freedom of Information Act complements our earlier discussion of the Open Meetings Act. Open, honest, and accountable government can only be achieved through the free and open exchange of information between the government and the public. We are privileged to have with us today Michael Luke from the Illinois Attorney General's Office. Michael currently serves as counsel to the Attorney General and ethics officer in the Office of the Attorney General. Mr. Luke is a frequent lecturer on issues relating to state and local government law and eminent domain. He's been an active partner in programming with University of Illinois Extension, serving both as a presenter for tele-institutes and editor of the Handbook for County Board Members. Thank you, Michael, for your support. If you're ready, let's begin today's discussion of the Freedom of Information Act.
If not, we got about a half an hour to run through the Freedom of Information Act, so we're going to take this one a little quickly. Again, I think that most public body members deal less frequently with the mechanics of the Freedom of Information Act and open meetings, but you need to have at least a foundation in this, and hopefully we'll give you that today. Freedom of Information Act became effective in 1984. It was amended effective January 1st, 2010, so just a little over a year and a half ago now, to address a number of problems that had arisen and became obvious over the previous 25 years. And one of the things that the Act did was to create the office or position of Public Access Counselor in the Attorney General's office. I referenced that earlier with respect to filing a complaint about the Open Meetings Act. Again, the Public Access Counselor also deals with Freedom of Information Act problems, and again, the primary purpose of the position is to try to mediate and remediate problems without people having to litigate. I'm a lawyer. I can tell you that when it comes to resolving an issue, going to court is about the least effective way there is. It's expensive, it's time-consuming, you have to go in front of judges, you have to find time for judges. It's really pretty ineffective. But what we plan to do, and what I think we're doing with the Public Access Counselor, is to give a lot of guidance and also to say to people when they do not comply with the Act, okay, you didn't comply with the Act, here's how you need to comply with it, please comply with it. And I think we're really getting very, positive, responses to that, and we are, in fact, able to help bring people into compliance with the Act without having to worry about litigating. The purpose of FOIA, again, is quite clearly stated by the General Assembly that the public has a right to records that pertain to what its government does, and that it's a fundamental obligation of the government to operate openly and to provide public records, subject, of course, to a number of exceptions. The definition of public records means essentially documentary materials that pertain to the transaction of public business, regardless of form or characteristics, that are prepared by, used by, in the possession of, controlled by, constructively controlled by a public body. Now, we added that language during the rewrite that's italicized pertaining to the transaction of public business to make it clear that there are a lot of communications that public bodies have that don't pertain to public business. And the example I always give, and I'll beat it to death once again, is that I have two daughters. They're at the point now where they ought to be independent, but they aren't. And periodically I get emails from them on my work computer saying things like, I'm overdrawn again. please put money in my account. Or if it's my older daughter who happens to be a doctor, it is, I got another speeding ticket. Do you know a lawyer in, fill in the blank, anywhere. These are not matters that pertain to public business. And as such, they're really not records of the Attorney General's office, and they're not FOIAble. And for purposes of retention, they can probably be disposed of without any great thought. The real problem has arisen largely in the last 10 or 15 years with emails because, again, most of the time, if the kids wrote us a letter saying, I'm busted, put money in the account, it went to home. And now, while you're working, you get the emails, or my wife says you want to have dinner, you want to have lunch, or do you remember your doctor's appointment, or whatever it is. All of these are outside the scope of being public records, and again, don't have to be ordinarily turned over pursuant to a FOIA request. So we chose that language. It came out of the Local Records Act specifically to make it clear that we do not expect every communication to be a public record of a public body. And again, I guess that's really what I wanted to say on that. Let's move on. Forget that for the moment. Again, electronic communications are now expressly included within the definition of public records, and that includes emails and other media that create a record. Now, that's in contrast, let's say, to a telephone conversation. We're talking right now, we're communicating, but there will not be, in all likelihood, a written record of this. There may be a recorded record under these circumstances, but again, if it was just me talking to one of you about a question you had, we don't record that. If you're recording it, you're eavesdropping and you're in violation of the law. It doesn't create a record. It will create a record of the fact that I either received a call and spoke for 12 minutes to somebody or that you made a call or whatever. But it will not disclose the actual substance of the call. Emails, Twitters, text messages do. They create records. And because they create records, that plops them directly into the FOIA matter. And I know what I was trying to get to briefly a moment ago. Let me just say that, our office has a reasonable use policy on our computers, which says that we can use our office computers, for personal emails, things of that sort, in a reasonable fashion, which means that if somebody's on personally emailing all day long, they can be disciplined because that's unreasonable, but we recognized a long time ago that the way things are now, this is sort of the wave of the future, and it's probably in many cases more effective, time effective, for one of our employees to receive a quick email than it is to make a phone call. So, you can answer the email when you're done with the latest project, whereas if it's a phone call, you do it right away. So I would suggest that whether you're going to allow employees to use their equipment for reasonable personal purposes or ban it altogether, you need to have a policy on that. And that's what I was trying to get to, because if you're going to discipline someone for making emails to family members and that, and you don't have a written policy in place saying that's prohibited, you're probably not going to succeed. So you need, as a public body or as the officers who have control of the systems, need to make determinations as to what kind of allowance of publicly owned and operated equipment you're going to permit. Now, definition of a public body for the Freedom of Information Act is virtually identical to that of the Open Meetings Act. It was taken from that. However, unlike the Open Meetings Act, the Freedom of Information Act is applicable to individual officers. So when we talk about a public body in this case, that would include officers such as the sheriff, the treasurer, the county board chairman, township officials, etc. They're going to be subject to FOIA even though they're not subject to the Open Meetings Act because they don't meet as a body. Again, there's a presumption of openness in all records. So if you have a record in your custody, or if you have a document in your custody, I should say more appropriately, then it's going to be presumed that that record is a public record. Now, if you say no, it's actually just a copy of an email from, Michael Luke to his daughter, then you can demonstrate that, then the presumption will disappear. But the presumption is going to be that if you got it, it is a public record. If it is not, you have to show that it is not. The person requesting the record never has the burden of showing that a record he or she requests that's in your custody is actually a public record. That is presumed. Generally, a public body has to respond to a FOIA request within 5 business days. That can be extended another 5 business days for a variety of reasons, such as there's a large number of records, you have to go off-site to locate the records, you have to meet with someone else to determine whether the information needs to be redacted from the records, which means taken out of the records. It's either it amounts generally to 7 or 14 calendar days. If there is a legal holiday in there, then that does not count. Saturdays, Sundays, legal holidays. All other days are business days. Again, a public body can either grant or deny a FOIA request, granted in part or denied in part. But again, whatever your decision, you need to notify the requester in writing, and if you're denying the request, the reasons that you're denying it, including a detailed factual basis for an exemption claimed, and the names and titles of the persons who made that decision. Now, a detailed factual basis changes depending on what exception it is you're citing. As you'll see in a minute, there is an exemption for what we call private information, such things as Social Security numbers. Your detailed factual basis in that case will be because it's a Social Security number and we're prohibited from disclosing it. On the other hand, if you have to go through 2 or 3 different analyses in order to finally get to the point where you decide that a record is exempt, you're going to have to detail that. You're going to have to show the person who's requested it the basis upon which you've reached the conclusion that they can't have this record. So that's why I say that the detailed factual basis, slides, if you will, on a sliding scale, depending on exactly how complex the analysis you make is. And again, if you notify, or when you notify someone of a denial, you have to notify them that they can seek a review from the public access counselor and give that address. That's on our website. You'll have that in your materials. We have forms for those things that you can simply copy and put in your own forms and use that. Also the right to seek judicial review under Section 11 of FOIA, and that form is also in our on our website. If you fail to respond to someone within the time that's permitted, either the 5 business days or the 10 business days, or as we will see in a little while with commercial requesters, it'll be 21 working days, then that is considered a denial. And if you then decide, oops, this sat on my desk for 2 weeks, I got the records, I'm going to send them out, Anyway, you can't charge a fee for that record. That's a little discipline for the public body for not being timely. And you also can't claim that it's an unduly burdensome request. So the magic to this is that, make sure you do something within the initial 5 or 10 business day period. Either deny it, grant it, extend it, but make sure you do something with it. Otherwise, you're going to have some of these things foreclosed, and you won't have a choice. Any questions up to this point before we go to the exemptions?
Michael, I don't know if this would be an appropriate spot, but can you share any of your knowledge or understanding of how local governments are putting systems in place to ensure that they're meeting those requests within that time period of 5 to 10 days?
I probably can't tell you a whole lot because I think that, one, the systems are still being developed, and two, we have like 7,000 units of local government in Illinois, so I don't think that there's any one acceptable thing. But one of the keys is, and I think we'll touch on this later, is that there must be a designated Freedom of Information officer or officers for every public body. Whether you have one or more is your choice. The city of Chicago, for example, probably has 20-odd, one for each of the major departments. And it is the FOIA officer's obligation essentially to track those things and to hound them. And so really the key to the system, I think, is to make sure that, one, anyone who sorts mail, receives mail, or whatever, is inculcated to the understanding that if they get something directed to a FOIA officer or a FOIA request, it is imperative that that go immediately to that person. And secondly, it's then up to the FOIA officer to make sure that he or she begins to process that and get it moving right away. And so the FOIA officer really becomes the focal point of the process. It's really an important position, and the more, the more comfortable a FOIA officer is with these jobs, then the more likely it is that you will find that things move in a timely fashion. Other than that, I regret that I can't really, give you specifics on how any particular body may be improving their own policies and compliance. Any other questions? Okay, exemptions. There are a bunch of them. Again, much like the Open Meetings Act, there are certain things, certain records that are sensitive and ought not to be open to sort of public scrutiny willy-nilly. The exemptions try to balance the right of the public to know and balance privacy interests and the needs of the public body to keep some information from the general public. One thing to note on exemptions is that, generally speaking, they don't prohibit the disclosure of information. They're really discretionary. Again, there may be some record that you could withhold that you say, well, that's not sensitive, I'll just give it out. That's not a problem. Of course, I would be very careful with any records that deal with personal privacy issues because then it's not just the public body's records at issue, it's a third party's privacy interest. And that person generally is not going to be involved or often will not be involved in the process to protect themselves. Again, if you have some record on a person who lives in the county and someone asks for it, you're probably not going to call the person up and say, do you mind if we give out this record? So that person's never going to be really involved in the process. So you need to be very careful to protect their rights. Other things, information concerning bidding or plans, things of that sort, that's really within the discretion of the public body. You can withhold them or not as you see fit. These are the general categories of exemptions. Personal privacy is one of the biggest, law enforcement and security. Educational matters, not so much probably for you. Most of those are pretty specific to schools. Legal proceedings, counties and other municipalities get sued. Internal operations, things like internal audits and that, you will deal with. Business and finance, and that's a general category that deals with things like contracts, buying and selling land, bidding and the like. So all of these, with probably the exception of educational matters, you may or may not encounter. But we're going to go over like three of the primary ones right now. There is a definition of private information. This is new as of 2010. Again, the key to this is private information as it's defined in the Act is exempt from disclosure, period. Again, this is the one where all you have to say is this is private information under Section 7(1)(b) of FOIA. We don't have to give it to you, and we're not gonna. And here's the definition. This is sort of the red flag items if you ever deal with the Securities and Exchange Commission and things of that sort. It's unique identifiers, a person's social security number or driver's license number, biometric identifiers, if you have a retina scan at your county, access codes, medical records, home and personal telephone numbers, and personal email addresses, as well as home addresses if that can be connected with an individual, and the same thing with license plates. Now, one thing I would just, as an aside, particularly with counties but also municipalities, is in some tax records, the fact that you have both a name and an address will have to be given out, because in some cases the tax code itself provides that people have access to that information. And frankly, if you're going to challenge a tax assessment or something, you probably need to know that information. So there are some exclusions. Another exclusion, if we have county clerks here, you probably know that there are certain records under the election code that include voters' names and addresses that have to be given out at certain times. And again, it's necessary to have both a name and an address to check the validity of persons who sign petitions and the like. So there are some exceptions, but outside of those, generally not. So again, the key to that is that's always exempt, and that's one I would never, vacillate on. I would never decide to give someone's Social Security number out. If it falls within that list, I would redact it under any circumstances. There's also Section 7(1)(a). Now, that was 7(1)(b). We're going back to this one. And that's information that's specifically prohibited from disclosure by federal or state law or rules or regulations implementing federal or state law. Again, sometimes for those of you who are familiar with HIPAA information, Health Insurance Portability and Accessibility Act of 19 whatever it is, you know that there are certain federal prohibitions against releasing certain health information. There may be other laws that, individual officers such as sheriffs deal with, where they may be prohibited from disclosing certain criminal information, conviction information under state law. Again, if you encounter one of those things, then technically it's exempt under Section 7(1)(a) of FOIA, and that is what you would cite. And hopefully you would also cite HIPAA or whatever the other law is. But note that it applies only when that law specifically prohibits a public body from releasing the information in question. So you have to know that it's not just something that you might withhold, it's something that you must withhold. And again, rules and regulations are not informal policies. or institutional guidelines, but formally adopted rules and regulations. Here's the big one, the unwarranted invasion of personal privacy. For those of you who have done this for a while, you remember there used to be several per se categories where it said personal information, it said information concerning people who receive benefits, and et cetera. Those are all gone. And it's been replaced by a general category that says that a public body can withhold personal information if the disclosure of it would constitute a clearly unwarranted invasion of personal privacy, and then it defines unwarranted invasion of personal privacy to mean the disclosure of information that is, one, highly personal or objectionable to a reasonable person, and in which the subject's right to privacy outweighs any legitimate public interest in obtaining the information. And then it goes on to say the disclosure of information that bears on the public duties of public employees and officials is not an invasion of personal privacy. Going to the last sentence first, that means, as it has certainly since before FOIA was even enacted, that things like the names of employees, how much they make, the positions they hold, what their job duties are, et cetera, cannot be withheld as a violation of personal privacy. Other information concerning third parties or that information you may have about a public employee that doesn't relate to their public duties can be withheld. An example is we sometimes get requests for W-2 forms. We get requests for other records that, say, pension records that have not only the fact that John Doe is a member of IMRF, and that under the formula he's required to pay in $200 a pay or whatever it is. But it also lists as beneficiaries and a bunch of information. The fact that he's a public employee, participates in a public pension plan, and he's required to pay money into it is probably all information that would have to be given out. The beneficiary information wouldn't. And if the person chooses, for example, to make additional payments into the pension fund that aren't required by law, that information would probably be exempt as well. And again, the courts have defined personal information as information that's private and confidential. Boy, that's not very helpful, but you get the drift, I think. Section 7.1F, this is one of our other major exemptions that we deal with, and that exempts preliminary drafts, notes, and other records in which opinions are expressed or policies or actions are formulated. This is the sort of thing where you put together an advisory body to the county board to advise on something like enacting a TIF district or some sort of zoning plan or whatever, and they exchange memos, they throw out plans, et cetera, and eventually they present something to the county board for consideration. Well, the final product is going to be something that's going to have to be turned over in all likelihood if requested, but the preliminary drafts, those back and forth discussions of policy and the like, ordinarily can be exempted from disclosure under Section 7.1F. The reason being that we don't want to discourage people from speaking their mind when they're trying to create or influence policy by the thought that their stupid idea might be disclosed at some point, or that someone who ought not to see it will get a hold of it. So this allows those types of documents to be withheld. In addition, there are a number of other exemptions that you should be familiar with, as well as references to other statutory exemptions that are in other acts, and those are now contained in Section 7.5. Again, this has always been kind of a headache because they really ought to all be listed in the Freedom of Information Act. but nobody has ever gotten around to doing that. But there will be a reference, for example, in 7.5 to exempting library circulation and order records that identify users with specific materials under the Library Records Confidentiality Act. And if you go back to the Library Records Confidentiality Act, there it will say these records are confidential. So not every exemption is included specifically in the Freedom of Information Act, but a good number of those that are located elsewhere can be found in Section 7.5. And you should refer to them. Now, commercial purpose requests I want to touch on briefly. Again, this is where somebody's going to use information for sale or whatever. There are a couple of changes. Again, news media, etc., is exempted out from commercial requests, even though they sell newspapers. Generally, you don't have to comply within 5 business days or 10 business days. You have 21 working days, and you must, within that period, let the commercial requester know that you're going to either provide the records, tell them when you're going to have the records and how much it's going to cost them, and you can require them to pay up front, deny the request if it's clear that they're exempt, or declare them to be unduly burdensome and that you're not going to comply. So, again, if the person comes in, and I know a lot of people have had some problems with various entities that seek land use records and the like for a commercial purpose, then you can kick them into the secondary category. And only recently, there's a general limitation on copying fees of 15 cents per page, and only after 50 pages. But with respect to commercial requests, you can now charge research time, but it's after 10 hours. And that would be 10 cumulative hours. If it takes 2 of your employees over 5 hours each to locate all the records, you can charge for that research time. That's never been permitted before. And there it is, up to $10 an hour that's spent, and that would be in addition to any cost of actually retrieving and transporting records from off-site storage, if you store them off-site, as well as any copying fees. So it's sort of three-party. And again, if you do charge someone, then, or at least a commercial requester, you have to give them an accounting of how you came up with your charges. Fees for electronic copies are ordinarily limited to the cost of the medium you use to go ahead and make that copy. Okay, recurrent requesters I want to mention real briefly. Nobody's kicked me off yet. This is a new one. Problems with people who make sort of serial requests. There is now a provision that says if a person makes 50 requests in a year, 15 requests within a 30-day period, or 7 requests within a 7-day period, other than newspapers and scientific entities, etc., then that person is considered a recurrent requester. You have to notify them that, and then you kick them from the 5 business day compliance period into the 21 business day compliance period, which means it's going to give you more time to deal with them. Okay, again, you have to respond within 21 days the same way as with a commercial request. Let them know if you have the records or you're going to furnish the records, how much it's going to cost. You can charge that up front. And again, unless the records are exempt, you're going to comply with it. You don't get to just say, I'm not going to comply with it because you requested 7 times in the last week, but you're going to kick them over into the slower track. Again, the Public Access Council, we talked about, you can take a look at this on the procedures. It's essentially the same as with the Open Meetings Act. Again, if we issue a binding opinion, the same The same alternatives are available to a public body. You can either comply with it or go to court. And we will issue advisory opinions if you have a specific question about a category of records and whether they would be subject to disclosure, for example, you can ask. Judicial enforcement, it can be enforced judicially. Again, it's not done often, but the key to this is twofold. A person who essentially substantially prevails, in other words, you denied them the records, they were entitled to the records, you're going to have to pay attorney's fees and costs. And if a person willfully refuses to comply, we've had that happen, you're the clerk, the clerk candidate who's opposing you in the election comes in and wants records, and you say, there's no way you're ever going to get records from me, and they file suit, that's probably going to be a willful violation, and the public body can be fined, essentially, between $2,500 and $5,000 per occurrence. And you'll have to explain that to the voters. Okay, conclusion, same people to call. And if you have any quick questions, if there's any time, then I'll try to answer those. Otherwise, feel free to call us at that number or to email us at the public access email box.
Thank you very much, Michael. At the beginning of the program, you talked a little bit about that there would be an online training certification program that's forthcoming. Can you say any more about that at this time?
What I can tell you really is that we're in the process of working on that. We do actually have an open meetings training course online currently, but now we're working on how to essentially document and update that system so that we can have a list of persons who have taken it that's more complete. But to the extent that, if anyone wants to go through that course, and I should mention this both for FOIA training and open meetings training, if you go to our website, you'll see a green box on the front that says Public Access Counselor, and if you click into that, you will be able to take either the Freedom of Information Act training or the Open Meetings Act training, or both, essentially as a guest if you're not a FOIA officer. It's free. It doesn't cost anything. It is informative. And again, there are a couple of logistical problems with it that we're still trying to work out in terms of, if you answer the question correctly, you may have to go back to the box previously in order to proceed to the next question. It's IT stuff. I don't know about it. But that is on there. That is available. And as soon as we have, the finalized Open Meetings Act training available for all members of public bodies, we will be advertising that fact.
Very good. Thank you. Any final questions for Michael? If not, I want to say thanks again. Wonderful program, great conversation throughout the presentation, and we very much appreciate your taking the time to be with us today.
And if I can say, on behalf of the Attorney General, Attorney General Madigan has been devoted to increasing transparency in government without trying to increase the burden on government. It's hard to do both, but on behalf of the Attorney General, we certainly appreciate that you took your time and came and listened and cooperated in this training, and hopefully we'll go away a little better educated and a little better public official than when you came. So thank you on her behalf.
Have a good evening, everyone.